Hello everyone. Team Corporate Law Journal welcomes you all for today's session. In this session, we shall be discussing about the draft of EIA Notification 2020. Before delving into today's discussion, please subscribe to the channel and press the bell icon for more updates on corporate and commercial laws. A signatory to the Stockholm Declaration 1972 on environment, India enacted laws to control water in 1974 and air in the 1981. But it was only after the Bhopal gas leak disaster in 1984 that the country legislated an umbrella act for the environmental protection in 1986. Under the Environment Protection Act of 1986, India notified its first EIA norms in 1994, setting in place a legal framework for regulating activities that access, utilize, and affect the natural resources. Every department project has been required to go through the EIA process for obtaining prior environmental clearance ever since. The 1994 EIA notification was replaced with a modified draft in the year 2006. Earlier this year, the government redrafted it again to incorporate the amendments and relevant court orders issued since 2006 and to make the EIA process more transparent and expedient. The draft of EIA 2020 norm basically highlights over increased discretionary powers of bureaucracy. The government can allow any company to start projects even without having environment clearances. Projects concerning national defenses and security are considered strategic, and other operations which the government considers as strategic. These strategic operations should be kept away from the public domain under the 7th point of the new notification. This shall open a window for summary clearance for any project deemed strategic without having to explain why. This new draft comes along with a lot of exemptions from the public consultation. For example, the linear projects such as roads and pipelines in borders will not require any public hearing. The border area as defined is an area which falls within the 100 kilometers of aerial distance from the line of actual control within the bordering countries of India. That would cover much of the northeast, the repository of the country's richest biodiversity. There will also be an exemption to all inland waterways projects and expansion, widening of national highways as well. The minister who will be concerned in charge of these sectors will also be exempted from giving prior clearance. These will include the roads which cut through the forests and dredging of major rivers as well. The 2020 draft also exempts most of the building construction projects of built-up area to 150,000 square meter. This is a reiteration of the Environment Ministry's December 2016 notification that was set by the National Green Tribunal in December 2017. The government subsequently moved the Supreme Court but did not get any relief. Coming to the factor of solar plant, there was a recent solar plant which was inaugurated in Madhya Pradesh and has led to a lot of drainage problem. There were several complaints by the local residents. As mentioned previously, that the 2020 draft has a new limit to up to 150,000 square meter, whereas before, earlier the buildings had a scrutiny of about 20,000 square meter or above, which required an environment clearance. But now there has been an extension in the limit as we see. There has been a big shift, and the two most significant changes in the new draft are the provisions for post facto project clearance and abandoning the public trust doctrine. Projects operating in violation of the Environment Act will now be able to apply for clearance. It is a reiteration of a March 2017 notification for projects operating without clearance. All a violator will just need to do are two plans for remediation and resource augmentation, corresponding to 1.5 to 2 times the ecological balance that has been damaged and assessed, and economic benefit derived due to the violation. For such a late application, a developer will have to cough up to Rs 2,000 to 10,000 per day for the period of the delay. On 1st April, the Supreme Court held that an ex post facto environmental clearance contrary to law, which said that an environmental law cannot continuance the notion of an ex post facto clearance. This would be contrary to both the precautionary principle as well as the need for sustainable development. This 2020 draft also spells out how the government will take cognizance of such violations. It has to be reported either by a government authority or the developers themselves. There is no scope for any public complaint about the violations. Instead, the reliance is now on the violators to disclose the suo motu that they break the law. Earlier, there was also a provision for public hearing of complaints which could be heard by the district collectors of the area. Now that they have changed the mode of public hearing, so it can be done either virtually or physically within the limits of the public participation. Coming to the legal aspect of the draft, there was an EIA notification which was issued under Section 3 of the Environment Protection Act of 1986. This draft was there to impose restriction on setting up of new projects or expansion or modernization of the existing projects. The section stipulates that such measures must benefit the environment. In the 1st of April order, the Supreme Court in their statement said that for an action of the central government to be treated as a measure referable to Section 3, it must therefore satisfy the statutory requirement of being necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling and abating the environment pollution. Lastly, coming to the overview of this draft, there was an unexpected delay in the publication of the draft in the Gazette due to the COVID-19 emergency. The Environment Minister Prakash Javadekar set the new deadline on 30th of June, limiting the extension to only 20 days, which was heavily criticized by the activists, and they had taken it up to the court. The activists had claimed that the 2020 draft is rather a regressive one from the 2006 version and it has to be replaced. The Delhi High Court extended till the 11th of August the deadline for the public feedback on the draft of the Environment Impact Assessment Notification 2020. The Delhi High Court has extended the window for public feedback to the draft of Environment Impact Assessment Notification 2020 to August 11th so that the changes which are proposed in the norms will be known clearly as to why they affect the activists. The Karnataka High Court directed the Ministry of Environment to not publish the final draft notification of the Environment Impact Assessment 2020 till September 7th. The court's order came on a petition alleging that the notification was not being sufficiently publicized amid the coronavirus crisis. The court also noted that since the draft Environmental Impact Assessment 2020 was published on March 23rd, 2 days before the imposition of the national lockdown to control the coronavirus, people had not been able to file objections to the document. This could appear to the public that the right of the citizens to file the objections has been taken away from them. The bench of the Karnataka High Court said that if the centre would be willing to grant sufficient time to the people to file their objection, it could apply for vacating the interim relief. The court's next hearing in the case will be on September 7th. The Karnataka High Court also benched to the objection to the centre's decision to publish the document only in Hindi and English, since there are several people in the state of Karnataka who don't understand either of the language. Lastly, it is advised that the viewers should send out their response to the email ID which has been mentioned in the last slide for the EIA draft of 2020. It is also advised that the viewers of the Corporate Law Journal must write their suggestions of the video and also the EIA draft of 2020 as per them. They should also highlight the suggestions as to what they feel so that the Corporate Law Journal could send out a consolidated suggestion to the government which will be helpful. People should voice out their opinion before this actually does become a law.